Yes, Peters.
My Lord, before I pick up where I left off this morning, there was one point I wanted to come back to that we were discussing to some extent earlier in the day. It's this question of whether the Richmond Lodge document could be said, as it were, to give rise to a freestanding duty of account. In other words, don't worry what went before. Somehow the acknowledgement contained in the Richmond Lodge document could get the claimants home by itself. The first point I make is that that's not a case that's fairly open on the pleadings. I think I've made that point. I'm not proposing to go back to the pleadings. But I do also say that it's not actually what the judge concluded. Your Lordships referred to paragraph 96 of the judgment, which is core tab 5, page 75, where the judge found as a fact that the Richmond Lodge document was proffered with the intention that it be a statement of account. So you have a finding of primary fact there, and the question is then, what legal conclusions did the judge say flowed from it? And that's where one gets to 120 and following of the judgment, which is page...
Are you drawing a distinction between what he intended it to be and what it was?
Well, I think that is a valid distinction, but for the purpose of this...
Is it a distinction you're drawing?
Yes, my Lord. I do say that a finding that the document was intended to be an accurate statement of account is not the same as a finding that it actually was.
Okay, well, I have to say I don't think that's your... speaking in terms of myself, I don't think that's your best point, given that the whole of the pages before is talking about what it actually was.
But my Lord, actually, the point I was going to make on this is a more fundamental one, which is that if you look at 120 and following of the judge's judgment, what he says is that there's a duty to account not, as it were, independently by virtue of the Richmond Lodge document. What he finds is that there's a duty to account, or what he concludes, is that there's a duty to account by virtue of Mr. Jassat's control of the Swiss accounts, and that's apparent from paragraph 120 in particular, which is at page 84. And then at page 85...
I'm sorry, it isn't apparent to me. Sorry to interrupt you so soon, but the defendant has had control of the claimant's monies and the investments made from these monies.
Yes.
Well, what are you saying?
Well, my Lord, the point I'm making is that the only control he is said to have had, that the means by which one gets to that control, is via the Swiss accounts. That is how my client exercises control over the claimant's monies. But what I say is that the way the judge approaches this is he finds the duty to account, and what he then says at 123 is, having found a duty to account, that the starting point for the taking of the account shall be the Richmond Lodge document, and that is 123. I wouldn't accept that it's a fair reading of paragraphs 120 to 123 as a whole, that the judge is there finding that the Richmond Lodge document engenders a freestanding duty to account if one otherwise would not have existed. I say you can't reasonably get that from 120 to 123, and if you can't, then particularly in the absence of a respondent's notice, you have to grapple head on with the issues that I was in the middle of grappling with before lunch, and to which I now propose to return.
Thank you.
So, my Lords, we were at paragraph 56 of the judgment at page 64 in the core bundle. And I'd read down to, I'm concerned with the dealings with money standing to the credit of the account holders of various Swiss bank accounts. And the judge says this: those accounts were initially in the names of the South African businessmen and may later have been transferred to accounts in the names of the defendant as their agent pursuant to powers of attorney granted to the defendant by them. Now, just pausing, first of all, the idea that and in fairness to the judge, I don't think this is actually what he meant. The proposition that the accounts were ever in the name of the South African businessmen themselves is wrong. And if we go to the judge's detailed analysis, which I'm about to, is accepted to be wrong. So I don't think that's what the judge actually meant. But this paragraph then does beg the question of, well, if it's not that the accounts are actually in their names, what is it that it, to the judge's, use the judge's phrase, makes it clear that the shows in action represented by the balance on the accounts belonged to or was held for the South African businessman, bearing in mind what I said just before lunch, that on the judge's analysis, this is not a case where one finds that there was some prior interest in the expatriated monies that can be followed into the Swiss account. So what is it about the Swiss accounts that engenders this interest? And for that purpose, one has to actually go back to what the judge says specifically about the Swiss bank accounts. And, my lords, that is at paragraph 42 and following of the judgment, which is page 61. So, my lord, starting at 42, there's a reference there to bank accounts being established under the defendant's control at BMC. The accounts were given names which disguise the identity of the true account holder. And it says initially the account holder was Mr. Hatharani, but to protect himself, Mr. Hatharani instructed the defendant and his bankers in the late 1980s to change the identity of the account holder to the defendant. Then at 43, there's a power of attorney to these accounts, which he says the defendant was given a power of attorney to control these accounts, which he says he did on Mr. Hatharani's instructions. And then at 44, Messrs. Sita, Gangat and Barwan come into the picture.
Well, you say they come into the picture there, but you started a little way into the story. If you go back to
yes.
the beginning of the expatriation funds, 36 and 37,
yes,
you have an agreement between the four of them as to the ownership of the funds. 40% for each of Mr. Hatharani and Mr. Sita, 10% for each of these claimants. And then you have, at 39, that it was Mr. Hatharani who organised it. He didn't pay it directly, he used middlemen and so on and so forth. And that he then opens an account. Now, when you read that with 37, why do you not draw the simple conclusion that the account is held beneficially for the four of them in those proportions?
Well, because the reason I do that is well, there are a couple of stages to that, my lord. What I am saying is that there was an initial question. It goes back to the point I made just before lunch, which is my reading of the judge's judgment, is that there is a question as to what are the actual interests in this money, this money that is expatriated. And there was debate about that at trial, and the judge deals with it briefly and doesn't deal with it fully, but that's not a criticism, because at 56 he says, I am not concerned with that.
Well, his conclusion, 56, is the shows in action represented by the debt owed to the account holder, originally Mr. Hatharani, subsequently your client, by the Swiss bank, was held for the four of them. And that's consistent with 37, where there's an agreement to that effect. And generally speaking, if I agree that I'm going to open an account for four people, it's held for those four people. There doesn't seem to be a difficult
No, my lord. The point I was lighting on is that begs a question of what the position actually was regarding the expatriated monies, and there is what I say is a slight oddity in the judgment, because the judge appears to say at the beginning of 56, I sort of don't need to worry about the expatriated monies, because what matters is the position regarding the accounts. So in other words, that there's something about you don't, as it were, look back to South Africa. You look at the accounts, and he says the accounts are in the name of the South African businessman, which on any view, as I say, they weren't. But there's a more fundamental point. It's not just the code names point, although there is that point. It's that actually, and I was going to come to this as I go through the paragraphs just after the one I've got to, that the most one can say is that there's, as it were, a top account that the judge himself describes as Mr. Hatharani's, which is the B kidney account, and then you have sub-accounts, and the claimant's sub-account is Camelot. And my lord, just to make good that last point, it said it was nevertheless common ground between the claimants and the defendant in their evidence, and then the defendant's amended third witness sorry, this is 48 of the judgment at page 62. It was nevertheless common ground, etc. That there was always at least one account of Mr. Hatharani's, which was earmarked to receive the funds on expatriation and before division between the South African businessmen. The account so used changed from time to time. Initially, at least, it was an account called B Kidney. Now, my lord, the point about this, and this is where this becomes... My lord, the point where the reason this becomes relevant is when you're talking about a duty to account in respect of the accounts, who has to account to whom? And it goes back to a point I made in relation to the pleadings, which is that it is not said on the pleadings that there was a liability to account in respect of the B Kidney account generally before, and I gave the example, the 1996-1997 payment of 2.4 million is made. And my lord, what we say is, what is the analysis of these accounts that is open to the judge on the evidence? I've dealt with this at paragraph 42.3 of my skeleton, at which is at core tab 10, page 169, so I can go through it quite quickly. But in effect, what was said in the pleading is that B Kidney and or Tyson were the claimants' accounts. You may recall that. The thrust of both claimants' oral evidence to the judge is that B Kidney and Tyson were nothing to do with them, in the sense of that was not an account of theirs, so that part of their case, namely, we paid money from our account to the claimant's account, breaks down, because what was said is B Kidney and Tyson are our account, Camelot is the defendant's account. In fact, on the evidence, B Kidney and Tyson are accounts of Mr. Hatharani's. The claimants say nothing to do with them. And the money is paid to Camelot, which is an account of the claimants. Now, where does that leave you? And my lords, again, I want to do this by reference to the 4 million and the 2.4 million. And I'm proposing to start with the 2.4 million. So the 2.4 million is paid from B Kidney and or Tyson to accounts called Cold Star and or Pitman. It's a payment from one account that is not the claimant's and which was controlled by Mr. Jassat to another account of which exactly the same can be said. And how is that supposed to engender a duty to account that did not exist before the payment was made? That's the issue with this payment, is when does the duty to account arise? And it's not said that the duty to account arises when the money is in B Kidney, notwithstanding that that is also an account under Mr. Jassat's control. So something has to happen as a result of that payment to create a duty to account in equity that did not exist before. And in my submission, there is nothing on the evidence or as a matter of analysis that tells you how that can work. But there is, at least in one sense, potentially an even more fundamental problem with this particular part of the claimant's case. It's pleaded on the basis that the claimants themselves transferred monies from an account of theirs to an account of the defendants, and pleaded that way. You can see how it falls squarely within an Alduason type case. Well, the problem is that's simply not what happened. And it's clear that that's not what happened from, amongst other things, Mr. Gangat's oral evidence. My lords, if you could take up my unagreed documents bundle. Yeah. And it's page two, tab 1, page 2, which is a bit of the transcript of day 3. And my lord, it's one of those quarter pages. It's page 27, which is the bottom left-hand side. And it's I want to start at line 9. This is a part of a question from me.
Can you give the page again? Bundle page.
Bundle page 2. That's it, bottom left-hand corner, page 27, line 9. Question from me. So just starting there. what this is saying is that actually you claimants transferred 12 million, of which 2.4 million was yours. Now, just to check, that's not actually right, is it? It's definitely, it's definitely not right. Mr. Jassat didn't get the money from us directly. The money came from Mr. Hatharani into those accounts. That was the big account. So what seems to have happened is not that the claimants ever themselves, which is what they allege to have happened, pay money to an account of my clients. What happens is that they appear to have hypothesized, by reference to the document which is quoted in the particulars of claim at paragraph 20, that such a payment would have been made. It sounds as though at the direction of Mr. Hatharani. And so the question then again is, well, we know that there's not a duty to account immediately before that payment is made. Sorry, a duty to account to the claimants immediately before that payment is made. So what on earth is there that causes the duty to account in respect of that money to come into being? And the answer in my submission is nothing. And the judge didn't make any findings in relation, relevant findings in relation to that sum of 12 million. All he records at paragraph 50 of the judgment, which is page 63 of the core bundle, is an allegation made by Mr. Hatharani that the 12 million was to have been shared, but as it were, into the individual accounts, but wasn't because my client made off with it, which interestingly is actually positively inconsistent with the pleaded case. So, my lords, we say that if you look at the available evidence, that the Al-Dwayson type liability to account in relation to the 2.4 million really doesn't work at all. My lord, that leaves the 4 million payment into the Camelot account. And that's addressed at paragraph 46 of my skeleton, core tab 10, page 172 to 173. And my lords, as you see, there are a couple of points to take about that. The first is a point on chronology, which I've made in writing. What I say is odd about that, and you will have seen from what I say in my skeleton. It might be said to be unattractive to take a point about a misdating of something that happened so long ago. And I would take that on a chin to an extent, but it is quite unusual here that from the very outset of the proceedings, we had been sort of screaming at the claimants that this couldn't possibly be right, and they stuck with it doggedly. But in any event, it's not my main point on Camelot. The more critical point in relation to Camelot is what is actually the state of play on the evidence as regards that account. So that is, it's slightly odd. It's said in the particular claim to be my client's account. It's actually not. On the evidence, it's the claimant's account over which my client holds a power of attorney. And again, it's common ground that the claimants had access to that account and indeed undertook transactions on it. And there are a couple of things that flow from that. First of all, it gives rise to an oddity if one is talking about an Al-Dwayson type breach of fiduciary duty case, in that actually the effect of the money being paid into the Camelot account was to increase the level of control that the claimants enjoyed over the money, and in some senses to decrease the control that my client had over it, because it involved effectively the monies being subject to joint control. But my lord, that matters, we say, in terms of how the claimants should be expected to come before the court. And I say it's a point I made briefly earlier. If I pay money to you as my agent and it goes into your bank account, I can ask you to account for all of that money. And the key point in that context is that unless and until an account is given, I have no way of establishing for myself what has become of my money. I am in your hands. And that in some ways, is the essence of what a fiduciary duty is about. But where the money remains in my account and I give you the power to make payments from that account, the position is very different. I myself can work out which transactions have been undertaken by you, and I can ask for an account in respect of those transactions. But, my lords, in my submission, it would not be appropriate in that scenario for me to be able to demand that you account in respect of all transactions on that account. Now, why do I say that? Because if the position were otherwise, then you, in this example, are having to account not just for what you have done with my property, but for what I have done with my property. And in the taking of that account, any ambiguities would be resolved against you, even if I, as principal, am responsible for the absence of documentation concerning the account. Now, my lords, here in relation to Camelot, if Mr. Jassat has any liability to account, it should be limited to transactions which he has undertaken, and the initial burden should be on the claimants to identify what those transactions are. If the position is otherwise, then Mr. Jassat has the burden of accounting as a duty, burden of accounting as a fiduciary for dealings, at least some of which were not undertaken by him at all. So we say that if the claimants want an account in respect of the dealings on the Camelot account, they should have come to court armed with particulars as to what those dealings were. Now, the reality is they cannot do that. But why not? It's because they were very keen that banking records for the Swiss accounts not be kept, and the judge made that point expressly at 16 of the judgment. And of course, the reason for that is certainly until at least the mid-2000s, they were very keen not to get caught by SARS in respect of the very significant fraud that they had perpetrated against it. Now, if as a result of that, the claimants have, in practical terms, placed themselves in a position where they are effectively disabled from coming to court to claim an account in the proper way, then the court should have precisely no sympathy with them. And indeed, any other approach risks being really quite oppressive to the alleged fiduciary, because, as I say, once the duty of a fiduciary to account is established, then any ambiguities or any gaps in the account are resolved against the fiduciary. So, my lord, in conclusion on ground 2, we say that the correct analysis is by reference to the legal principles on which the judge himself relied. The claimant's case as pleaded doesn't work on a number of levels. For reasons I've said, it only even really begins to get off the ground in relation to the 4 million paid into the Camelot account, and only then if the claimants are allowed to run a case which is inconsistent with their pleading. And in any event, even that part of the case does not work for the reasons that I have just given. So, my lord, now I was proposing to deal, and I think I can deal relatively briefly because we've already touched on it, with ground 3, which is addressed at paragraphs 48 to 52 of my skeleton, core 10, 174 to 175.
Thank you.
Now, the judge's conclusion on this point is at paragraph 123 of his judgment, which we have looked at. It's core 5, page 123, but I think we all have it well in mind. Now, we have two criticisms of the judge's reliance on the Richmond Lodge document. First, we say that the question of the actual state of account between the parties, whether at 2009 or any other date, was simply not an issue which was properly before the judge at all, and it was therefore inappropriate for him to address it. And second, and it's a point I've already made to some extent, that his reasons for addressing the point were incorrect as a matter of analysis. Now, I want to deal with the second of those points first, because we've already touched on it. I can deal with it briefly. It's, again, the starting point is his reasons for refusing permission to appeal, core 687, which we've looked at, in which he said, in relation to ground 4, the court has to decide the nature and the scope of the account to be directed. And yes, but that does not provide any sufficient reason for anchoring oneself to a financial statement produced decades after the fact. As I've said, the judge concluded that Mr. Jassat's ability to account arose from property being placed under his control such that he received it in an accountable capacity vis-à-vis the claimants. on that basis, the scope of the account is very easy to define. It's a point I've made before. An account should be ordered in respect to the relevant property. And as I've explained in relation to ground 2, the property in question is clearly identified in the amended particulars of claim. And if it hadn't been, then the claim might have faced a more fundamental issue. So we say that the reliance on the Richmond Lodge document is an incorrect solution to what is in fact a non-existent problem. But going back to the first objection, which is whether the accuracy of the document was properly before the judge at all. Now, as the judge remarked at paragraph 1 of his judgment, which I don't think we need to turn up, that this was a trial of liability rather than quantum, and the relevant order is, which we've looked at briefly, and I think we can just go back to again, is at supplemental tab 1. Now, if we start at page 4 of the supplemental bundle, you'll see paragraph 1, this is the order itself. Paragraph 1 provides for a trial of specific issues. And then if you go to page 7, and we've been here before, this is the list of issues for trial on liability. And it starts with issues of primary fact. And if you go to issue 16, which is page 9, it says the circumstances in which the Richmond Lodge document was produced. Because there was a debate between the parties, as I'm sure your lordships are well aware. We were saying it was produced in one way, claimants were saying it was produced in another. But not the true state of account between the parties at the time that document was produced.
I'm very sorry, I just don't understand this. Paragraph 24.
Yes.
In a claim where there is a claim for an account,
Yes.
one of the issues is to what extent the defendant is a trustee of the claimants and so on and so forth.
Yes.
I don't want you to repeat your submissions about whether or not they're a trustee.
Yes.
But isn't that a clear indication on its own that the end of the liability trial should define the scope of any account that's going to be taken?
Well, I don't object to that, my lord.
Well, that's what he's done.
But what I object to is, in circumstances where that can very easily be done, the account can be ordered in respect of the property that is held as a
I know you
fiduciary.
don't like the terms of it, but can we just be entirely clear?
Yes.
You don't object to the taking of an account, given his findings?
Yes, I accept it was entirely appropriate for the judge to order, assuming his judgment is otherwise right, I entirely accept that it was appropriate for the judge to order an account. And what I say is the question is an account of what? And the answer, there was an easy answer available, an account of the property received by Mr. Jassat in an accountable capacity. And the question of what the precise state of account between the parties actually was at an intermediate date between when the liability to account arose and when the actual account was to be taken is not an issue that we say was properly before the judge. And, my lord, there is quite a good practical reason for that, which is, of course, if the judge were really grappling with not just, as it were, the circumstances surrounding the production of the Richmond Lodge document, but its objective accuracy, then you have at that point blown up the distinction between liability and quantum. Because in order fully to grapple with that point, you would have to ask yourself, well, what actually is the state of account? There would have to be disclosure of all the financial records, as at 2009, so that one could test the objective accuracy of the Richmond Lodge document. And at that point, you have completely defeated the purpose of a split trial. Now, I understand that it is one of the potentially perilous features of split trial that you can end up with issues that sit close to the split. But in policing that boundary, one has to be practical, and taking a line on what issues are in play at liability that is inconsistent with the disclosure that has been ordered, and as I say, very substantially explodes the distinction between liability and quantum, is, we say, not appropriate. We do also say that there is a further particular problem with 1, 2, 3 of the judgment, because the judge purported to find that the Richmond Lodge document was an agreed statement of account. Sorry, if we could just go to that. It's right at its core tab 5, page 85. So he says, I will hear submissions on the form of order, but the starting point for any accounts and inquiries should be the Richmond Lodge document, which is, in my judgment, an acknowledgement by the defendants of the state of account as between the claimants and the defendant, which the claimants accepted and agreed. Now, I do say that this is the problem with the point being canvassed by the judge in circumstances where I do say it wasn't front and centre. I've taken you to the passages of the pleading. That finding was actually not, that last bit of that finding was definitely not open to the judge. Because what is the pleaded case is that the Richmond Lodge document was inaccurate, and in fact that the service of it by Mr. Jassat was a breach of fiduciary duty. Now, my lord made the point earlier that is the Richmond Lodge document, as it were, an agreed minimum. But that's actually not the judge's finding. The judge's finding is that it's an agreed statement of account. And that was neither party's case. And that is, in my submission, as it were, a symptom of the difficulties that one can get into when the court starts grappling with issues that are not fairly and squarely before it, as I say they weren't, and with which it doesn't need to grapple for the purpose of fashioning an account.
On that point, if you took out the last sentence and a half of 1, 2, 3, so that it stopped with the words, an acknowledgement by the defendant of a state of account as between the claimants and the defendant, full stop, could you object to that?
Well, I couldn't object to it on the narrow basis of my last point. I couldn't object to it on the basis that it's not open on the pleadings. But, my lord, in my submission, particularly in circumstances where we don't have a respondent's notice, one oughtn't to be in the territory of, as it were, actually changing the judge's findings in that way. Because then effectively what one is saying is the judge couldn't find what he actually found, but he could have found something less than what he found. And that in my submission is not right.
It seems to me the claimants could complain, if you're right, that they never agreed it, and there was no evidence they ever agreed it. So they ought to have been entitled to take the acknowledgement as an acknowledgement, but ask for more if they could prove it. But they haven't. There's no respondent's notice seeking to go further. But why is the judge's conclusion that it's an acknowledgement by the defendant of the state of account as at that date, as a minimum? Why is that not open to him?
Well, I don't say it's not. I don't say it's not open to him because it's inconsistent with the pleading. I say that it's, if what he is in effect saying is that the Richmond Lodge document is an accurate, an objectively accurate and binding statement of account,
yes, I see,
as at that date, that is not a matter that was properly open to him because it's not.
So your query is, your purpose is to ensure that the use of the word agreed is not translated through to the taking of the account to mean agreed in every respect as the full and complete account.
Absolutely, my lord. And just to be clear, the court may or may not have this point in mind. The judge may have made clear in his order, and it was clear at the consequentials hearing, that what he was saying is that there's no ability on the part of either party to go behind the Richmond Lodge document. The Richmond Lodge document effectively is a year zero for the purposes of taking the account. And it is, my lord, in terms of substance, it is that to which I object. That is, sorry, I perhaps should have made that clearer at the outset. That is the point that we say is objectionable. And just on my lord's question, I see the point you make about the agreement and how in some ways it would be, if anything, the claimant's point to take. But I was just giving it as an illustration of the difficulty one gets into when a point is grappled with, which in my submission is not front and centre for the purposes of the liability trial. But my lords, I think I've said all I can usefully say on ground 3. So, my lords, unless there are any further questions from any of your lordships, those are my submissions.
Thank you very much. Mr. Khan, I think we'll just take a minute to take stock. We'll just go outside for a moment and then we'll come back. Mr. Khan, we don't need to hear from you. Thank you very much. We have reached a clear conclusion that this appeal will be dismissed. We will give our reasons in writing in due course in the normal way with an embargoed draft, with an invitation to identify typos and obvious errors, which, as you both know, is not an opportunity to re-argue or to do any more than that. The terms of the embargo will be well known to you. I can't tell you when that will be, but it will be as soon as reasonably practicable. Thank you very much, Mr. Peters. We are against you, but it's not for want of trying on your part. Anything else I need to say? No. Thank you very much.
All right.